Professor Dr. Mohan Bolla sir, and to everyone. A warm good morning and a heartiest welcome to each of you for joining in today's fifth episode of late Niranjan Kumar Narjari Memorial Online Lecture Series. Actually, the title of the lecture series was proposed to us by Professor Dr. Mohan Bola sir. So we have incorporated your suggestion, sir, with due
Thank you.
respect.
Thank you. Thank you.
And,
Thank you very much for introducing us to your students and also the others, madam, for staff members also. Now, I am delivering my lecture whether the material is needed or can I give lectures? Tell me.
Yes, sir.
So we will introduce you first.
Okay. Because time is up. Time is up. Yeah.
No problem.
To all the participants and student friends and teachers of other institutions. Heartiest welcome to each of you to our lecture series. And thank you to IQAC team of Kokrajhar Law College for organizing such program during the time of pandemic in order to continue the academic activities and for the interest of all. Thank you to each of you, and once again a heartiest welcome. Welcome to you, sir. Over to you, Duhita.
Thank you, Principal Madam.
Thank you.
So before going to start our technical session, I am taking the privilege to introduce our speaker, Professor Nagabhushanam Tida sir, who is going to enlighten us on the topic Muslim law of inheritance. Professor Nagabhushanam Tida sir has been working as an associate professor of law at Dawa University, Ethiopia since 2017. He is the former principal of BNR College of Law, Himavaram, and CGSKM Law College, Rajahamantri, and previously he has also served as a lecturer of law in various law colleges in India. He has also worked as a company secretary at ASN Association, Visakhapatnam, and moreover, he also is a visiting professor in ICFAI and Appala University of LLM Distant Mode of Education at Delhi, etc. So we are honored by your presence in today's session, sir. Once again, a heartiest welcome to you, sir. Now the platform is all yours, sir.
Now, sir can begin.
Over to you, sir.
Right. Okay. Shall I take, madam?
Yes, yes.
Yes, sir. Yes.
Namaste to you all. So, I will deliver the lectures that is orally, without seeing, without showing any of the material. Okay, madam? Shall I deliver lectures or show the material?
What can be done as you please.
What is okay, sir? What is okay?
Delivery lecture.
Yes, sure, sir.
Okay, I will send the material to you by email. Okay.
Okay,
madam.
sir. Okay.
Okay, right.
Okay, sir.
Right.
Okay.
Thank you very much. So now I am going to deal with the Muslim law of inheritance. Inheritance means if one person who died, then in what way the property will be devolved upon the legal heirs, provided that no will which is left by the propositors. Propositors means deceased owner of the property. So here, whenever a person who died without the execution of will, that person is known as propositors. So, on the death of the person without execution of will, then in what way the property will be devolved upon the legal heirs, that is discussed under the Muslim law of inheritance. So here, inheritance when it would be applicable. So, without the execution of will, there is the inheritance. And will which may be executed by the testator, but under the Muslim law, only up to 1/3 of the value of the property, the will which may be executed by the testator. But even for that 1/3 value of the will also, at the time of execution of will, if he is suffering from insanity or mental abnormality, then even up to that 1/3 also there is no such value of the execution of will. So for the entire property, the inheritance which would be operated. So in such way, the property will be devolved upon the legal heirs whenever a person who died without execution of will. This is the principle. Next is that the that is general rules towards the application of the provisions of the Muslim law of inheritance. General rule is that doctrine of near and dear. Doctrine of near and dear. So the nearest person is the dearest person under the Muslim law. Nearest person is the dearest person under the Muslim law. Suppose son and son's son, which is left by the propositors, then son's son will be avoided from the inheritance under the Muslim law, unlike in case of Hindu and Christian laws. So son and son's son, that is predeceased son's son, which is left by the propositors, then son is only entitled to get the property by leaving the that is son's son. So he will be disqualified because of present that is son which has been present. This is why why the property will be devolved upon the legal heirs, basing upon the principle of doctrine of near and dear. Nearest person is to be treated as the dearest person under the Muslim law of inheritance. Either under the Sunni law or under the Shia law, this principle is the same. Next, another one is that the schools of Muslim law. In what way? The schools which are applicable. So here, mainly two schools are there. First is the Sunni law. Again, Sunni law is subdivided into 4 schools. Next, Shia law. Shia law is subdivided into 3 schools. Now come to Sunni law. Under the Sunni law, the 4 schools which are there, that is Hanafi, Shafi, Maliki, Hanbali. These are the 4 schools which would be applied in case of Sunni law. And in case of Shia law, Ithna Ashariya, Ismailia, and Jaija. These are the 3 schools which are there under the Shia law of inheritance. Here, most of the population and majority of the population of our Muslim brotherhoods are belong to Sunni law. That is why we are concentrating on the Sunni law only. So, under the Sunni law, again, 4 schools are there. That is Hanafi, Shafi, Maliki, Hanbali. So, Hanafi law of inheritance, we are following. That is why, under the Hanafi law, I am going to explain about it. Here, under the Hanafi law, the division of the sharers, division of the legal heirs are 3 kinds. That is mainly sharers, residuaries, distant kindred. Sharers, residuaries, and distant kindred. Who are the sharers, who are the residuaries, and who are the distant kindred, which is explained under the Hanafi law of inheritance. So, sharers are of 12. Sharers are of 12. So, here again, sharers are divided into 3 kinds. That is primary sharers. Primary sharers means definitely share will be given to them. And substitutes to the primary sharers. That is, they are stepping in the shoes of the primary sharers. Substitutes, these are the substitutes. Because if the primary sharer is not there, then these will be taken into consideration as the substitute. Next, the brothers and sisters. Brothers and sisters. Now come to primary sharers. Primary sharers are of 5. That is, wife, husband, wife, in case of absence of the husband. Husband in case of absence of wife. Wife, husband, daughter, father, mother. These are the primary sharers. Under that, 5 are there. That is wife, husband, daughter, father, mother. Next, substitutes to the primary sharers. Son's daughter, how low soever. True grandmother, how high soever. I will narrate it. And true son's daughter, how low soever. True grandfather, how high soever. True grandmother, maternal, paternal, how high soever. These are the 3. These are the substitutes. They will enter into the shoes of the primary sharers if they were dead. If they were dead. Next is brothers and sisters. These are consisting of 4. That is full sister, consigning sister, uterine brother, and uterine sister. These are 4. So 5 plus 3 plus 4 is equal to 12. 12 legal heirs are there. These are mainly primary sharers. So the primary sharers are entitled to succeed the quantum of the property and substitutes. If no primary sharers, that is 5, then substitutes will enter into the shoes of the primary sharers and brothers and sisters. So exclusions which are also there. So here now come to the residual. I will tell you, because the totally sharers, residuaries and distant kindred must be known to you. There is residuaries which are there. So here, what is the position of the residuary? After the deduction of share of each of the sharer, if anything will be remained, then residuaries are entitled to succeed the quantum of the property. Suppose mother is there, son is there, some principal is there. In case wherever a Khan left son, that is the children, then mother's share is 1/6. So mother's share will be 1/6 which would be given. Then the remaining balance, because son is the residuary, the remaining balance of 5/6 which would be given to the son. If 2 sons are there, 5/6 into 2. 3 sons are there, 5/6 into 3. In such way, the property will be devolved. Now come to the residuaries. Residuaries are of 18. That is, son's son howsoever, father, true grandfather howsoever, full brother, full sister, consigning brother, consigning sister, full brother's son, consigning brother's son, full brother's son, consigning brother's son. Next, full paternal uncle, consigning paternal uncle, full paternal uncle's son, consigning paternal uncle's son, full paternal uncle's son, consigning paternal uncle's son. Next, full paternal uncle's son's son will come. Consigning paternal uncle's son's son come. Like that, the residuaries which are treated here. So here, 18 residuaries are there. I already told you that is son howsoever, father, true grandfather howsoever, full brother, full sister, consigning brother, consigning sister, full brother's son, consigning brother's son, full brother's son, consigning brother's son, full paternal uncle, consigning paternal uncle, full paternal uncle's son, consigning paternal uncle's son, full paternal uncle's son, consigning paternal uncle's son. These are the 18 members which are there, but here first one will be preferable to the second one. Suppose son and son's son is there. So under the residuaries category, son is first category. Second one is son's son, how low soever. Then son's son will be excluded from the purview of inheritance in the presence of the son. This is the important thing which is to be noted here, because the Muslim law, that is Hanafi law, says that doctrine of near and dear. Nearest person will be considered as the dearest person under the Hanafi law of inheritance. So these are the 18. Next come to distant kindred. Distant kindred, actually, if the sharers and residuaries are there, then distant kindred will not get any of amount of the property by way of inheritance. But that is in some of the circumstances, if nobody else, then distant kindred will also come into the picture for the inheritance of the property. Who are the distant kindred? So here, daughters' children and their descendants, sons' daughters' children and their descendants, false grandfather, false grandmother, full brother's daughter and their descendants, consanguine brother's daughter and their descendants, full brother's son's daughter and their descendants, consanguine brother's son's daughter and their descendants, and the uterine brothers' children and their descendants, and the sisters, uterine, that is full blood, half blood, or uterine blood, or whatever, and their descendants. Like that, 18 members are there. That is full paternal uncle's daughter and their descendants, consanguine paternal uncle's daughter and their descendants, full paternal uncle's son's daughter and their descendants, consanguine paternal uncle's son's daughter and their descendants, and the paternal, that is uterine paternal uncles and their descendants, paternal aunts and their descendants, maternal uncles and aunts under the descendants. In such way, 18 members are there under the distant kindred. Actually, there may be they may not be entitled to inherit the property if nobody else in there. That is sharers and residuaries, especially wife or husband which are there. If nobody else, then distant kindred will come into the picture for the inheritance of the property. Now come to the tabular form, that is sharers. Who are the sharers? Under the Anaphyla, I already told you that is primary sharers are of 5. Primary sharers are of 5. That is, I told you, wife, husband, daughter, father, and mother. So in what way the shares which are allotted under the Anaphyla, that would be discussed here. Wife share is 1/8. Wife share is 1/8. If 2 or more are there, even in such case also 1/8. The normal condition is that if there is the son, if there is the son means to the husband, there must be, there is the children, children. If the Khan died intestate, so 4 wives are permitted under the Muslim law. To any of BB, if any children which are begotten, then ultimately the share of all of the 4 wives are 1/8. Even 1/8, one person may be there 1/8, or 2 or more may be there 1/8. The normal condition is that if there are no children. Here, if there is children, then, if there are the children, then 1/8. 2 or more also 1/8. If there are no children, then share will be enhanced up to 1/4. So, the share of a wife or wives are 1/4. So, in such way, share is allotted. Next, come to husband. Husband share is 1/4. 2 or more, no. That is not permitted. So, normal condition is that if there is children. If no children, then the husband share is 1/2. That is 1/4 will be enhanced to 1/2. In such way, the that is the ratio which is specified there. Next, daughter. Daughter share is 1/2. 2 or more, 2/3. Normal condition is that if there is no son. If no son, then she becomes sharer. Next is, if son is there, then along with the son, the daughter is residuary. Residuary means the remaining balance which would be shared by the residuaries. The remaining balance which would be shared by the residuaries. So here, the sharers are nothing but lions. The residuaries are nothing but foxes. Because after taking away the important parts of the body, lion will go. Then fox will be, that is concentrating on it, whatever the remaining food, then they will take away. Like that, these are the foxes, that is the lion. Okay? So understand in this way, in the simple way. Right. So here, daughter 1/2, 2 or more 1/3. Normal condition is that if there is no son. If there is son, daughter will be residuary along with the son. Daughter will be residuary along with the son. Suppose, for example, I am telling you, son, daughter, widow. Then share of widow is 1/8 because children are there. Daughter, son, widow. Widow share is 1/8 because children which are left by the propositous Muslim. Okay. The remaining balance 7/8. That 7/8 will be distributed to the residuaries because residuaries will be entitled to get the remaining balance. After the deduction of 1/8, the remaining 7/8 is there. That 7/8 will be distributed to son and daughter. Here, one point is to be remembered. Son will be given 2 quantum and daughter will be given 1 quantum. That is why 7/8 into 2/3 to the son and 7/8 into 1/3 to the daughter. Suppose 4 sons and 4 daughters are there. Then 4 into 2, 8 plus 4, 12. So 2 by 12. That is the 7 by 8 into 2 by 12 will be given to each of the son. 7 by 8 into 1 by 8 to each of the daughter. In such way, the distribution which would be made in case of the daughters which are there in the presence of the son. Okay. Otherwise, daughter is only the sharer. As the sharer, if we won only 1 by 2. If 2 or more are there, then 2 by 3. That would be given. That is the daughter. Next, father. So, father share is 1 by 6. 2 or more, no. Father share is 1 by 6. So, that 1 by 6 he will be entitled to get it when in the normal circumstances, the that is father share 1 by 6. What are the normal circumstances? The normal circumstances are that if there is no child or child of a son, howsoever. If there is no child or child of a son, howsoever. So here, in case of a wife, in case of the husband, and in case of father, this is the first principle. That is, if there is no child or child of son, howsoever, then share will be fluctuated. If there is no son or no son's son, no child of son, howsoever, then automatically the share will be enhanced. That may be doubled. So father is 1 by 6, and the 2 or more, no. That is why dash we have to put on the table. I will provide the table also. And later, normal condition is that if there is no child or child of a son, howsoever. If there is child or child of son, howsoever. Next, another point is that if no child or child of son, howsoever, the father becomes residuary. If no child or child of son, howsoever, then father becomes a residuary. Suppose, for example, the widow and son and father are there. Then widow will be given 1 by 8 because of son, and father given 1 by 6 because of son. The son will be entitled to get the remaining balance, that is 1 by 6 plus 1 by 8. That would be added, and that would be deducted from 1. Then some quantum will come that would be obtained by the son as the residuary. Suppose if no son, if no child or child of son, howsoever, then father is residuary. Suppose wife is there and father is there, then wife share is 1 by 4 because there is no child or child of son, howsoever. Then father becomes residuary because there is no child or child of son, howsoever. In such way, the calculation which would be made, some typicalities, but the thing is that if you can find the table, then automatically you will understand. I will provide the table to you. Next, another one. Father share is 1 by 6. If there is no child or child of a son, howsoever. Next one is that if there are, another point, in the father only, if there are daughter or daughters, if there are daughters, or son's daughter, or son's daughters, howsoever, then father will be considered as sharer as well as residuary. See, sharer as well as residuary. Madam, in so many textbooks, principal madam, hello?
Yes, sir. Yes,
Principal
yes.
madam, in
Yes.
so many textbooks, some mistakes are there. If you are finding any textbook, any difference between my lecture and textbook, then presume that the textbook is mistaken. My
Okay, sir.
lectures are correct, okay? With
Okay.
utmost confidence I am telling you, okay?
Okay, sir.
Right.
Okay.
So, father is sharer as well as residuary. Suppose wife, daughter, father are there. Then wife will be given 1 by 8 because of daughter. Daughter will be given 1 by 2. Daughter will be given 1 by 2 because it is one only. Then what is the position of the father? So father is sharer as well as residuary. 1/6 will be given to the father as the sharer, and the remaining balance, that is 1/8 plus 1/2 plus 1/6. This would be added, and that would be deducted from 1. Then some figure will come. That would also be given to the father, because as the residuary, he is entitled to succeed the quantum of the property of the remaining balance. This is the principle. As the sharer and as well as residuary, he is entitled to succeed the quantum of the property. Next, another one, mother. Mother share is 1/6. 2 or more, no. Okay. Normal condition is that if there is child or child of a son, how low soever, then mother's share is 1/6. Later, if no child or child of son, how low soever, then mother's share will be enhanced to 1/3. Mother's share will be enhanced to 1/3. Second point is also there in the mother. So here, if mother is left by the propositors, and if only one brother or only one sister which is left by the propositors. Suppose if only sister or brother only left by the propositors, then mother's share is 1/3. It means if plurality of the brothers and sisters or brothers or sisters which are left, then mother share is 1/3. If only one brother or one sister, either full, consanguine or uterine blood, then the share of the mother is 1/3. Third point is also there in the mother. That is, third point is that if wife or husband coexisting with the father, if wife or husband coexisting with the father, then mother share is 1/3 residue after the deduction of.
Sir, you are muted. Please unmute. On the left side, the mic button, no? Left side of your laptop. No. In your, sir, if you are facing the laptop, if you are facing your system, then in the center there are 3 buttons: left, middle, and the right side. The left side is the mic. Yes.
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 Okay, na?
Okay.
No, okay. Right. So previously listened, madam. Previously listened, you listened these things.
Yeah. It was fine.
Okay. Now only problem came. Okay. Thank you, sir. Thank you. Right. If wife or husband coexisting with the father, then mother's share is 1/3 residue after the deduction of wife or husband share respectively. So here only 2 points will come in this, 2 problems will come in this particular aspect. That is wife, father, mother. Wife, father, mother. So this is the principle. If wife or husband coexisting with the father, then mother's share is 1/3 residue after the deduction of wife or husband's share respectively. Then wife's share is 1/4. Okay, because there is no children. Father's share is father's share is residuary actually. Father's share is residuary because there is no children. So after the deduction of wife's share, that is 1/4, then remaining balance is 1/3. In that remaining balance of 1/3, 1/3 residue will be given. So 1/3, that is 1/3. Remaining balance is that is after the deduction of wife's share 3/4. 3/4 into 1/3. Then what would be 3/4 into 1/3? Then 1/4. So 1 by 4 is given to be given to the mother, and later these 2 will be added, and that would be deducted from 1. Then father is the residuary. So as the residuary, he is entitled to succeed the property after the deduction of wife and mother's share respectively. So in this case, mother's share is 1 by 4. Next, another problem is also coming. Father, husband, mother. Then in such case, what would be? So the husband share is 1 by 2 because there is no child or child of a son, how low soever. Then after the deduction of wife, that is husband share 1 by 2, remaining 1 by 2 is there. In that 1 by 2, 1 by 3 share will be given to the mother. 1 by 2 into 1 by 3, that is 1 by 6. That would be given to the mother. Then the remaining balance after the deduction of the husband and the father's share, husband and husband's share and mother's share, the father is entitled to get the remaining balance, that may be 2 by 6. So in such way, the property will be devolved upon the legal heirs like that up to the mother. So the up to 8th point we discussed analytically. Next come to 5 points which are discussed. Now come to 6th point. Son's daughter, how low soever. Who is son's daughter, how low soever? First of all, that must be noted. So according to the Muslim law, son's daughter, son's daughter, but son's daughter's daughter is not coming within the picture. Son's daughter, son's daughter, son's daughter, son's daughter. In such way, all are sons, and later in the last only daughter will be there. Then son's daughter, how low soever. Her share is 1 by 2. She is stepping into the shoes of the daughter. Son's daughter, how low soever, is stepping into the shoes of the daughter. So here, that is the principle. So here, son's daughter, how low soever, 1 by 2. And if 2 or more are there, then 2 by 3. The general provision is that if there is no any child or child of a son, how low soever, this is the principle. If there is no child or child of a son, how low soever, then 1 by 2, 2 by 3 will be applicable. So when share will be affected and how share will be affected, that is also important thing. When share will be affected. So here, she is excluded by son's daughter is, because son's daughter is stepping into the shoes of the primary sharers, because she is the substitute. So son's daughter will be entitled to get 1 by 2, 2 by 3, provided that if no legal heirs, these legal heirs will not be there. If these legal heirs will not be there, no son, she is excluded by the son, higher son's son, son, higher son's son, 2 or more daughters, 2 or more higher son's daughters, 2 or more higher son's daughters, that is son's daughter is left here. 2 or more higher son's daughters means son's daughters are more, that is 2 or more. They will exclude from the purview of the inheritance in case of a son's daughter which is left. So in such way, it would be calculated. Next one is that the son's daughter, how low soever, the principle which is operated here. Next is true grandfather, how high soever. So in what way? True grandfather, how high soever, share will be allotted. 1 by 6. 2 or more, no. That's 2 or more, no. True grandfather means father's father, father's father's father, father's 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 father, father's 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 father. So these are the true grandfathers. Only father's line which would be accepted in the ascending order. This is the principle. So true grandfather, how high soever. His share is 1 by 6. 2 or more, no. That is excluded by whom? Father. If father is there, true grandfather cannot be entitled to get a share. Nearest true grandfather. Suppose father's father's father is there, then nearest true grandfather is father's father. Then he will be excluded. Father's father will come into the picture. So in such way, the share will be allotted. Next one is that is when share affected. True grandfather share will be affected when if there is no child or child of son howsoever, then true grandfather is the residuary. The residuary balance which would be given to the true grandfather. Okay. So suppose wife and true grandfather are there. Wife will be given 1/4 because there is no children, and true grandfather will be given the rest of the balance of 3/4. So in such way, he becomes a residuary. And the next one is that if there are only daughter or daughters, or son's daughter or son's daughters howsoever, and no son and no son's son howsoever, then true grandfather is sharer as well as residuary. True grandfather is sharer as well as residuary, like that of the father. This is the principle which is incorporated here. Like that of the father, the true grandfather share will be allotted like that. Next, true grandmother, maternal and paternal. Maternal true grandmother means mother's mother, mother's 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 mother, mother's 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 mother, etc. So only mother's line, true grandmother, maternal. And true grandmother paternal means father's mother, father's father's mother, father's 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 mother, etc. That is totally fathers and last mother. That is true grandmother paternal. So here, in what way the property will be devolved upon the true grandmothers? For both of them, it is specified here. For both of them, totally true grandmother and maternal and paternal, 1/6 only one, 1/6 only be given, two, that is 2 or more will be there. 1/6 only is given. So here, excluded by whom? Father, that is, in case of true grandmother paternal, I am telling. True grandmother paternal is excluded by father. And the nearest true grandmother, maternal or paternal. Suppose father's father's mother is there. Father's mother is excluded by father's mother and mother's mother also. This is the principle. True grandmother, maternal or paternal. Next is the nearest true grandfather will also exclude like that. So in such way, the father's mother will be excluded. Mother's mother will be excluded by whom? By mother. Mother's mother is excluded by mother. And the nearest true grandmother, nearest true grandmother will exclude the mother's mother. Suppose mother's mother's mother will be excluded by mother and mother's mother. So nearest. So here, nearest true grandmother paternal and nearest true grandmother maternal. Nearest true grandmother paternal is excluded by father. Nearest true grandfather, that is father's father's father, father's father's mother is excluded by father. Excluded by father's father. Nearest true grandfather, howsoever. Next, mother. Mother will also exclude the nearest true grandmother paternal. And nearest true grandmother, either maternal or paternal. So here, father's father's mother will be excluded by father's mother and mother's mother also. So in such way, 4 persons will exclude the true grandmother paternal howsoever. True grandmother maternal howsoever is excluded by mother, nearest true grandmother maternal or paternal. So here, father or nearest true grandfather will not exclude the mother's mother, mother's mother's mother, etc. True grandmother maternal will not be excluded by father and the nearest true grandfather howsoever. This is the principle. So 8th point is over. So here Eighth, that is, sixth one is son's daughter, howsoever. I already told you that son's daughter, howsoever means son's daughter, son's daughter, son's daughter, etc. All are sons, later only daughter. True grandmother, true grandfather, howsoever means father's father, father's father's father, father's 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 father, etc. True grandfather, howsoever. Howsoever means the that is that is what is that? In the narrower way, the upside, father's father, father's father's father, etc. So, in such way, the true grandfather will be constituted like that. And true grandmother, maternal. True grandmother, maternal. Mother's mother, mother's mother's mother, etc. will come as a true grandmother, maternal. True grandmother, paternal is father's mother, father's father's mother, father's 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 mother, etc. will come into the picture as the true grandmother, paternal. So, in such way, that would be calculated and their share will be given. Now, come to brothers and sisters. Brothers and sisters. These are constituted as four. These are constituted as four, brothers and sisters. Either full or consanguine or uterine. So here, full means father and mother is same. I think clear? Father and mother is same. Suppose X is there, X father A and mother is B. Father and mother is same. X is the full brother to that particular propositus. Brother means brother of the deceased party. That is important thing. You can see. From the point of view of the propositus only, we have to calculate. That is important thing. We have to construe that words from the point of view of this person. That is person who is propositus, who is the deceased owner of the property. That is important thing. So full brother, full sister, etc. will come. That is the full blood. Full blood means father and mother is same. So X and Y, X and Y. X died without execution of will. Y is the brother. If these two are begotten, these two are begotten to the same parents, mother and father, then these are full brothers or full sisters. So sister may be there, then she becomes full sister because their parents are same. That is, the Khan and BB is the same. Okay. Next, consanguine blood. Consanguine blood. Consanguine means to first BB, one children, son is there. To second BB, one daughter or son may be there. This son and that son is consanguine brother because mothers are different and father is same. Father is same. Uterine brother or uterine sister. So here, the fathers are different, but the mother is same. Mother is same. All are begotten to her, but their fathers are different. This is the uterine brother. In some of the circumstances, it may be happened. That is the BB. That is, X is married. X is BB. X is married to Y. And one child is begotten. That is, one son is begotten. Then the husband died. Then later, second marriage took place. Second marriage has been taken place. Then another another husband, to this BB, one son or one daughter will be there. Then what is the relationship between the first husband's son and the second husband's son of the same mother? Then these are the uterine brothers or uterine sisters. Then it is construed like that. So now come to 4 points. that is 4 legal heirs under the brothers and sisters. Full sister. So full sister is 1/2 and 2/3. Full sister share is 1/2 and 2/3. She will be excluded by son, son's son, how low soever, father, true grandfather, how high soever. These 4 persons will exclude the full sister. If a full brother which is there, then unless she is excluded from the purview of inheritance, then along with the full brother, she takes as the residuary. She takes as the residuary. Suppose one problem may come. Wife and full brother and full sister are there. Then in what way the property will be divided? Full brother and full sister. See, the full sister along with the full brother, she will become the residuary. After the deduction of wife share, that is 1/4, because there is no any child or children or child of a son, how low soever, the remaining balance 3/4 will be distributed among the brother and sister. So brother takes 2 quantums and the sister takes 1 quantum. That is, after the deduction of wife share 1/4, the rest of 3/4 into 2/3 to each to full brother, 3/4 into 1/3 to the full sister. In such way, they will that is share the property. Okay. Next, consigning sister. I already told you that father is same and mothers are different. So here, in such case, in what way the share which is allotted? Consigning sister 1/2, 2/3. She is excluded by whom? She is excluded by son, son's son, how low soever, father, true grandfather, how high soever, full brother, 2 or more full sisters. So she is excluded by more number of the person. That is, along with the persons who excluded the full sister, 2 persons are added. Full brother will also exclude, and 2 or more full sisters will also exclude the consigning sister. Suppose if the consigning brother is there, provided that if she is not excluded from the purview of inheritance, then consigning sister becomes the residuary along with the that is consigning brother. Consigning sister is the residuary along with the consigning brother. So in such way, shares will be calculated. Suppose, for example, I am telling you, mother, full brother and full sister. Mother, full brother and full sister. Mother will be given, hello. Mother will be given 1/6 because of the mother will be given 1/6 because brother and sister are there. Plurality of the persons are there. So the mother given 1/6. The rest of 5/6 will be given to the full brother, that is consigning brother and consigning sister, 2:1. That is 5/6 into 2/3, 5/6 into 1/3. In such way, the property will be devolved upon the legal heirs like that. Next, another point is that the uterine brother and uterine sister. Uterine brother and uterine sister. For all of them, shares which are calculated. If one uterine brother or one uterine sister, which were left by the propositors, then 1/6 will be given. Suppose 2 or more which are left by the propositors, then the share will be enhanced. That is 1/3 will be given. 1/3 will be given. So they are excluded from the purview of inheritance. In what way? That is the full brother or full sister excluded by child or children. Excluded by child or children. Next one is son's daughter, how low soever. Children of son, how low soever means son's daughter and son's son, how low soever may also exclude. That is children of son, how low soever. That is son's son, how low soever. Son's daughter, how low soever. Next. So here, in such way, father and a true grandfather, however. So in such way, the property will be devolved upon the legal heirs and they are excluded from the purview of inheritance in such way. This is the sharers category and 12 members are there. They are entitled to succeed the quantum of the property in such way. This is the principle. Next is the residuaries. That is, I will analytically explain about it. So, residuaries, son. Son is not there in the list of the sharers. So, son is residuary. Son is residuary. With the daughter, he takes double quantum. With the daughter, he takes double quantum. That is, son will be given 2 quantums and daughter will be given 1 quantum. I already told you in case of daughter, with the son, along with the son, she becomes residuary, I told you. So, the daughter becomes residuary in the presence of son. So, son will be given 2 quantums and daughter will be given 1 quantum. Suppose wife, son, daughter. Wife will be given 1 by 8 because children which are left by the propositors. Then 7 by 8 is there. 7 by 8 into 2 by 3 to son. 7 by 8 into 1 by 3 to the daughter. In such way, the property will be devolved upon the legal heirs. The procedure is like that. Next one is son's son, how low soever. Son's son, how low soever. Son's son, how low soever means son's son. Son's son's son, son's 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 son, son's son's son. So it is the descending order. So here, how high soever means ascending order, how low soever means descending order. Only sons will come into the picture. Son's son, how low soever, will be entitled to succeed the quantum of the property in the absence of the son. And among sons and soever, the nearest sons and soever will be preferred to the remote sons and soever, because the doctrine of near and dear, which is said to be operated in case of unlawful law of inheritance. So sons and soever is over. With son's daughter soever, son's son soever becomes the residuary. Son's son soever becomes a residuary with the son's daughter soever. In the son's daughter, I already told you that 1 by 2, 2 by 3, that is the sharing ratio. But if the son's son soever is there, then the son's daughter soever in the equal category will become the residuary along with the son's son soever in the equal category, but not as the sharer. That is the principle. That is why son's son soever will take double quantum and son's daughter soever will take a single quantum after the deduction of sharers' shares respectively. This is the principle which is operated. Next one is father. You know about the father. So here father is residuary. When if no son or son's son soever. And in father's category, I already told you, actually he is the sharer. His share is 1 by 6. His share is 1 by 6. Provided that when, if no child or child of a son soever, then father becomes residuary. That means if child or child of son soever which are present, then father's share is 1 by 6. So this is the principle. Suppose, for example, I am telling you, 3 points, that is 2 examples I will tell you on the same categories. Father, son and daughter. Father, son, daughter. So here father's share is 1 by 6 because of presence of son and daughter of the propositors. Then 1 by 6 will be deducted from 1. Then 5 by 6. 5 by 6 into 2 by 3 to son. 5 by 6 into 1 by 3 to the daughter. Daughter is not sharer here because along with the son, the daughter will become residuary. Father is sharer only because in the presence of the children or child of a son soever, then father is the sharer only. He will be given 1 by 6. Suppose father and daughter are there. Father and a daughter are there. Then daughter share is 1/2. She is not residuary now. See, in the previous problem, daughter is the residuary along with the son. Here son is not there. Daughter will be given 1/2 and father's share is, if there are daughter or daughters or son's daughters whatsoever, and if no son or son's son whatsoever, then father will be treated as sharer as well as residuary. So here the father along with the daughter, father and daughter only are there. Then the father as the sharer 1/6 will be given, and rest of 2/6 will also be given to the father because he is sharer as well as residuary in case of only the daughter or daughters or son's daughters which are left by the con, that is by the propositors. This is the important one. So the son's daughter, howsoever, next father is over. Next, true grandfather, howsoever, same principle. True grandfather, howsoever. Mother, that is mother, true grandfather, howsoever. Mother share is 1/6 because there is no child or child of a son also. The true grandfather, howsoever, because there is no father, the true grandfather, howsoever, is entitled to succeed the property. So the rest of 5/6 will be given to the true grandfather, howsoever, because as the residuary, he is entitled to succeed the entire quantum of the property. Next one is the full brother. So full brother is residuary. Along with the full sister, her share, that is his share is double quantum and her share is single quantum. Suppose mother, brother, sister which are left. Mother share is 1/6 because only one brother, that is one brother and one sister which are left. That is plural sisters and brothers which are left by the propositors. Plural, that is two or more. Then mother share is 1/6 and rest of 5/6 will be allotted to the brother and sister. Brother will be given 5/6 into 2/3. Sister will be given 5/6 into 1/3. In such way, the property will be divided. Next is the full sister. So here, full sister along with the full brother, she becomes residuary. Next, another point is also there. If there are a daughter or daughters, or son's daughter or son's daughters howsoever, in the absence of son or son's son howsoever, then full sister will become residuary. Full sister will become residuary. So the example I am telling you, daughter and full sister. Daughter and a full sister. Then daughter will be given 1/2 because only one daughter which are left by propositors. Full sister along with the daughter, if the daughter which are left by propositors, then full sister will become residuary. So 1/2 will be given to the full sister. Suppose 4 daughters and one full sister is there, then 4 daughters will be given 2/3 because 2 or more which are left by the propositors. 2/3. Then full sister will become residuary. So 1/3 will be given to the full sister. In such way, the shares which would be calculated in this way. That is, full sister is over. Next, consanguine brother. Consanguine brother. So with consanguine sister, he becomes residuary. So suppose mother, consanguine brother, consanguine sister. Then mother share is 1/6. Consanguine brother 5/6 into 2/3. Consanguine sister 5/6 into 1/3. In such way, the property will be divided. Suppose wife, mother, consanguine brother, consanguine sister. Then mother share is 1/3, wife share is 1/4, and the remaining balance after the calculation, that is, these two will be added, and that would be deducted from 1. The remaining balance which are there, that remaining balance only be given to the consanguine sister because she is the residuary. If brother is there, brother and consanguine sister will share that property in 2:1 ratios. That is the principle which is incorporated here. 1 minute. Right. So, in such way, the property will be divided. Next is full brother's son. Like that. Consanguine brother's son. Full brother's son's son. Consanguine brother's son's son. Full paternal uncle. Consanguine paternal uncle. Full paternal uncle's son. Consanguine paternal uncle's son. Full paternal uncle's son's son. Consanguine paternal uncle's son's son. These are the 18 members. Again, I am telling you for your reference. Right. Son, I already told you. Son, howsoever. Father, true grandfather, howsoever. Full brother, full sister, consanguine brother, consanguine sister, full brother's son, consanguine brother's son, full brother's son's son, consanguine brother's son's son, full paternal uncle. Paternal uncle means father's brother. Paternal uncle means father's brother. Full paternal uncle, that is full blood, which would be taken into consideration. Next is consanguine paternal uncle. Full paternal uncle's son, consanguine paternal uncle's son, full paternal uncle's son's son, consanguine paternal uncle's son's son. These are nothing but the residuaries. So, one by one, one by one, one by one. First will be preferred to second. Second will be preferred to third in the absence of first one. Fourth will be preferred to third in the absence of the above. So, in such way, we have to calculate it, and there is a relationship which would be taken into the consideration. Next is the distant kindred. So, distant kindred, which is tough one, then I can show it and I will tell you that is relationship. I will show it and I will tell you, you can see this one. Right. See, distant kindred, these are consisting of 18. Whether it is appearing, hello?
Yes, sir. Yes.
Yes, sir.
Oh, right. Here, distant kindred, children of daughter and their descendant. See, daughter's son can be entitled to succeed the quantum of the property if nobody is there, no any sharer and no any residuaries which are shown already, which are explained already in the last class. That is in the previously. Okay. So residuaries are 18. See, this one, madam. 18 residuaries are there. In the absence of the sharers and residuaries, then children of daughter, daughter's children, daughter's son or daughter's daughter will be entitled to get it. So here, then up to this, whether the property comes here, no, consanguine paternal uncle's son's son, full paternal uncle's son's son. Later, 19th point is 17th son will come. 18th point son will come into 20. Like that, it would be construed like that. But here, distant kindred, in some of the circumstances, if nobody else which were left by the propositors, then these persons will be entitled to succeed the quantum of the property like that. So, children of daughter, that is daughter's son, daughter's daughter, and daughter's children, daughter's son's children, etc. will come into the first category of distant kindred, provided that if nobody else which are left by the propositors only, it will come into the picture. Next, second one. Children of son's daughter and their descendants. So, son's daughter is the sharer, as well as residuary along with the son's daughter. Like that, daughter is sharer and daughter is residuary along with the son. That is specified. But daughter's son, daughter's daughter is not specified in the sharer's list or residuary's list. Children of son's daughter. Son's daughter is sharer. With son's son, she becomes residuary. But children of son's daughter is not specified. That is why it has been put in this category. So, children of son's daughter's son, son's daughter's daughter, and their children will come into this particular second point. Third one, false grandfather. Who is false grandfather? False grandfather means father's mother's father is false grandfather. Father's father's father is the true grandfather, how high soever. False grandfather means father's mother's father, mother's father, mother's father, etc. Because if any female will come in the relationship, then after that relationship, the person will become false. So, false grandfather means mother's father, mother's mother's father, father's mother's father, etc. etc. So, mother is included in any of the way. Next, false grandmother. Here, mother's father's mother, mother's father's mother, mother's father's mother's mother, mother's father's father's mother, etc. will come into this fourth point, that is false grandmother. Fifth point, full brother's daughter and their descendants. Full brother's daughter and their descendants. So, full brother is specified in the residuaries category. Full brother's son's son is also stated in the residuaries category, but full brother's daughter is not given. So, full brother's daughter and their descendants under the fifth column. Next, consanguine brother's daughter and their descendants. Consanguine brother's son, son's son, etc. that is specified under the residuary category. Consanguine brother's daughter is not specified. That is why the consanguine brother's daughter and their descendants, which were applicable here in the sixth point. Next is children of uterine brothers and their descendants. Children of uterine brothers. So, uterine brothers, who is uterine brother? Mother is same, father is different. Fathers are different, I told you. Suppose BB is married to a Khan number 1. So, after giving birth to one person, he died. Later, BB has married another Khan number 2. And in that also one that is son or daughter which has been begotten. Then in such cases, these two are uterine brother or uterine sisters. Uterine brother or uterine sisters. So uterine brother means mother is same, father are different. So the propositus, that is deceased owner of the property, is begotten to one Khan number 1. And his uterine brother, as is specified here, it is begotten to Khan number 2. But BB is same. So this is specified under the 7th point. Next is full brother's son's daughter. Full brother's son is stated there, but daughter is not there. Full brother's son's daughter is the distant kindred, and his descendants, and their descendants are also coming within this 8th point. Next is 9. Consanguine brother's son's daughter and their descendants. So, consanguine brother's son, residuary. Daughter is not specified in any of the place. So, here in 9th place, consanguine brother's son's daughter which is specified. And their descendants which are also coming within this purview. Next is children of sisters. So, the propositus may have sister. Deceased owner of the property may have the sister. That sister may be full, consanguine or uterine. I already told you in the beginning. But again, that is for analyzation, I am showing it. So, full, that is children of sisters. Full sister may be, consanguine sister may be, uterine sister may be. It is specified under the sharers category. See, full sister. When it is specified, 9th point. Consanguine, 10th point. 11 and 12, uterine brother and uterine sister, 12, 11 and 12. And their descendants, that is, children may be there, that is, sisters may be there, the sisters' children, full consanguine uterine. If they will die, then these children will come into the picture of point number 10. Next, full paternal uncle's daughter. Full paternal uncle is the residuary. His daughter is under 11th point of distant kindred. So, full paternal uncle's daughter and their descendants. Consanguine paternal uncle's daughter and their descendants. Consanguine paternal uncle is residuary. His daughter is stated under 12th point. Uterine paternal uncles and their descendants. See, full paternal uncle, consanguine paternal uncle stated in the residuaries category. Uterine paternal uncles are not found in anywhere else under the sharers or residuaries category. That is why uterine paternal uncles themselves treated as point number 13, and their descendants will also come in this particular point. Next, full paternal uncle's son's daughter. Full paternal uncle's son is residuary. His daughter is coming within the purview of 14th. So, the property will be devolved in the absence of all of them, that is sharers, residuaries, up to 13. If nobody else, then only it come into the picture, full paternal uncle's son's daughter and their descendants. Like that, consanguine paternal uncle's son's daughter and their descendants. This is also there. Consanguine paternal uncle is the residuary. His son is also residuary. That son's daughter is the distant kindred. Next, paternal aunts. Paternal aunts. Paternal aunts are not shown in any of the place of the sharers, residuaries or whatever. So they are treated as 16th point, that paternal aunts may be full blood or consanguine blood or uterine blood. So these are all coming within the purview of the point 16 and their descendants. And next one is maternal uncles and aunts. See, maternal uncle is not specified there. Aunts are also not specified there. So in this 17th point, maternal uncles either full consanguine or uterine, and maternal aunts either full consanguine or uterine, and their descendants will come within the purview of the point number 17 of distant kindred. Next is 18th point, any remote degree. So their children, etc. Remote persons may also be taken into the consideration. This is the principle which is to be applicable here. Next one is that, any doubt in this regard, madam? Is there any doubt?
No, sir, it is very clear.
No. Okay, it is clear. Next one is, shall I go to doctrine of owl and doctrine of rod? Doctrine of owl and doctrine of rod. Now I am going to explain it. Okay?
Okay, sir.
What is meant by owl and what is meant by rod? So basic principles I am telling you that in some of the circumstances, only the sharers which are there, in some of the circumstances, only the sharers which are left by the propositors and the sharers shares all together may come more than one or lesser than one. More than one means 3 by 2, more than one. Lesser than one means 3 by 4, that is lesser than one. Okay, na? So in such circumstances, the doctrine of owl or doctrine of rad, which would be applicable. So here, doctrine of owl, I am explaining. Owl means increasing. Doctrine of owl means increase. Increase means increasing the denominator so as to equivalent to that of the numerators. See, the increase of denominator so as to equivalent to that of numerator will be known as doctrine of owl. In some circumstances, the sharers only which are there and sharers shares altogether comes to greater than the unity. That is 4 by 3 or 5 by 3, 5 by 4, like that. In such circumstances, Muhammad Prophet simply said that the denominator which would be enhanced so as to equivalent to that of a numerator. So as to equivalent to that of a numerator. Then the problem will be settled. Suppose mother, husband, two daughters are there. Mother, husband, two daughters are there. Mother share is 1 by 6th. Father share is 1 by 4th. And two daughters share is 2 by 3. Mother, husband and two daughters. Mother share is 1 by 6th. Husband share is 1 by 4th. And two daughters share is 2 by 3. Then altogether it is more than 1. 1 by 4 plus 1 by 6 to mother plus 2 by 3. How much? You can calculate it. Then it will become more than 1. See, calculate and tell me. Calculate and tell me 1 by 6 plus 1 by 4 plus 2 by 3. It is very tough one. That is why.
13 by 12, sir.
13 by
12.
13 by 12. So here, whether the denominator is lesser than the numerator or not,
Yes.
the denominator is lesser than the numerator. Numerator is 13, denominator is 12. Okay? Right?
Yes, sir.
13 by 12. In such cases, 12 will be made as 13. 12 will be made as 13. Then in what way? So numerators, how much? It becomes 13 plus, you can tell me. 1 by 6, how much? Numerators, yeah. One by 6 plus 1 by 4 plus 2 by 3. So 12. 2 plus 3 plus 4. So 2 plus 3 plus 8 by 12 is equal to 13 by 12, isn't it? Whether it is correct or not?
Yes, sir.
Hello.
Yes, sir.
Hello? 2 plus 3 plus 8 by 13, isn't it?
Yes, sir.
Right? So, 12 will be made as 13. You can make it as 13. Then 2 by 13, 3 by 13 and 8 by 13. That is the share, allotment of the share in case of owl. So, you are increasing the denominator so as to equivalent to that of the numerator. This is the principle which is applied here. You are increasing the denominator so as to equivalent to that of the numerator, which is known as owl. I think clear? So, equivalent to 1. 5 by 13 plus 3 by 13 plus 8 by 13 is equal to 13 by 13 is equal to 1. You can see.
Yes, sir.
Okay?
Yes, sir.
Correct or not? Tell me.
Yes, sir.
Altogether it comes to 1. Then
sir.
only the problem will become right. Okay, na? The problem will be right. Next, another problem I am telling you. Alright, so I will show the problems there in the see. You are seeing the problem, huh? Hello.
Yes, sir.
Hello.
Yes, yes, sir.
Yes, it is appearing. You are seeing.
Yes, yes.
Right. So, all. Okay. Example. Husband, two full sisters. Husband, two full sisters. Husband will be given 1/2. Why? There are no child or child of a son, howsoever. Two full sisters will be given 2/3. Okay, because two are left by propositors. 1/2 plus 2/3 is equal to what? That is important thing. So that is denominator, you can calculate it. 6. 6 means 3 plus 4. 7/6. 7/6 becomes 7/7. So you can increase the denominator so as to equivalent to that of numerator. So 7/7. Then the husband share will become 3/7 instead of 3/6. And the full sisters 2 share will be 4/7 instead of 4/6. So here, whether the ratio which is decreased or not, by such way the fraction of a share which would be reduced accordingly by enhancement of the denominator so as to equivalent to that of the numerator. Okay, I think clear? Clear?
Yes, sir.
Okay, right. So here, another problem I am telling you. So the difference between Sunni and Shia, you will get confusion, no need. I will tell you later. Right. So the following examples of the doctrine of increase. Husband, full sisters, mother, these three are there. Husband is given 1/2 because there is no any child or child of a son, howsoever. Full sisters will be given 2/3 because 2 or more which are there. Mother is given 1/6 because of 2 full sisters. If 1 full sister will be given, then mother share is 1/3. 1 full sister share is 1/2. That is principle. But here in the problem it is given that 2 full sisters 2/3 is given. Mother will be given 1/6 because of 2 full sisters. Then come to the calculation. 6, that is denominator. In the 6 you can calculate 3 plus 4 plus 1. Correct? Is it correct? 3 plus 4 plus 1/6. 3 plus 4 plus 1/6, it comes like that. Then 6 will be made as 8. Then 3/8, 4/8 and 1/8. So in such way, the fraction of the share will be reduced accordingly by the enhancement of the denominator. Enhancement of the denominator. Suppose 1 bag rice is there, 10 members are there. 1 bag rice is there, 10 members are there. 10 members, 10 shares are there. Then in such cases, 10 kg, 10 kg, 10 kg, 10 kg, we have to distribute it. Suppose 20 are there, then what can we do? 20 are there. Then 5, 5, 5, 5. Whether it is reduced or not, according to the number of members and their shares which are there, that is shares which were given, which is more than the unity, then this is the principle which would be adopted. Any doubt is there, you can ask me. Then I can clarify it. Then later I will go to Madam.
Sir,
Is there any doubt?
so the participants will put the queries in the chat box so we can take it later on. So the queries will be put in the chat box.
Okay. Right. Okay. Right. So this is the principle. Because in the beginning, if it is clarified, then that is subsequent lectures will be understood. That's why with that point of view, I asked. Right. Husband, mother, and two daughters which are left by the propositors. So, husband, mother, two daughters. See, husband share is changed. Husband share is 1/4. Previously, husband share is 1/2 in the previous problem. Why? There are daughters here. This is important thing. Mother share is 1/6 because of daughters here. Two daughter share is 2/3. Two daughter share is 2/3. Then we can say that 1/6 plus 1/4 plus 1/6 plus 2/3 is equal to, in what way? 3 is to 2 is to 8/13. 3 is to 2 is to 8/13 will come because 12 will be made as 13. 12 will be made as 13. Previously, before that problem, 3 plus 2 plus 8/12 will come. If you work out the problem, then 12 will be made as 13. Then in such case, 3/13, 2/13 and 8/13. So 3/12 will become 3/13/13. In such way, equivalent to 1, which would be coming into the answer. Next is another problem. Widow, mother, two full sisters. Widow will be given 1/4. Widow will be given 1/4. Mother is given 1/3 because one only full sister which is left by the propositors. If only one brother or one sister, either full, consanguine or uterine, then their share will be like this. Mother share will be 1/3. So 1/4 will be given to widow because no children. Mother share is 1/3 because only one full sister. Full sister share is 1/2. Okay. Then it comes 3 plus 4 plus 6. That is 13/12. It comes 3 plus 4 plus 6/12. That means 13/12 it comes. Then 13 will be made as 13. 12 will be made as 13. Then in such case, 3/13, 4/13 and 6/13. So it is equivalent to 13/13. In such way, the property will be divided upon the legal heirs. Next is husband. Husband, father and mother. Husband, father and mother. In what way? The property will be divided along with 3 daughters. Then husband share is 1/4 because there are the daughters. Father share is 1/6 because there are the daughters. And mother's share is 1/6 because there are the daughters. So totally 15/12. Totally it becomes 15/12. Actually, father will become sharer as well as residuary here because only daughters which are left. But here there is no any amount which is remained. That is why as the sharer, the father is given 1/6. So totally it comes all together 2 plus 2 plus wait. 3 plus 2 plus 2 plus 8/12. That is 3 plus 2, 5, 7, 7 plus 8. 15/12 it came. Then 12 will be made as 15. 15/15. That is 3/12. That is 3/15, 2/15, 2/15, 8/15. In such way, the shares will be allotted by reducing the fraction of the share by enhancement of the denominator. This is the doctrine of owl. So, next come to Rad. Okay? Rad I am explaining, madam. Doctrine of Rad.
Yes, sir. Yes.
Here, in some of the circumstances, if all shares which are left by the propositors and totally altogether all shares may become lesser than the unity, that is lesser than 1. So in such case, in what way the property will be divided upon the legal heads? Then the rad which would be operated if the denominator which is more than the numerator, denominator which would be more than the numerator, then rad which would be operated. That is, in case of absence of all of the shares and residuaries, in case of all of the absence of residuaries, only shares which are left by the propositors and the quantum of shares of all of the shares may come altogether lesser than the 1, that is the unity. Then in such case, we can say that 2 by 3, lesser than the unity or greater than unity? It is lesser than the unity. Then 3 becomes 2. 3 must be made as a 2. And by such way, the fraction of the share will be enhanced as per the province of the doctrine of rad. So here, some of the exceptions which are there in this rad. The wife or husband share remain constant. Husband or wife share will be remain constant, and there is no any change of husband or wife share. So they are not entitled to get the return. Their share will be remain constant. Next, second one. In the absence of shares and residuaries, the distant kindred also entitled to share after the deduction of wife or husband share respectively. In the first point, I already told you that husband share is remained constant. So, in the absence of all of the sharers and the residuaries, if distant kindred are eligible for the entitlement of the property by way of inheritance, then as the husband or wife share is remained constant, then the distant kindred are entitled to succeed that property after the deduction of wife or husband's share, that is a fixed share, husband or wife fixed share. After the deduction of that, the share that is remaining balance which would be distributed to the distant kindred. This is the principle. Suppose wife which is left by the propositors and also daughter's son left by the propositors. Then daughter's son is the distant kindred. So here, if no any sharer or residuary, then only these persons will come. So in such cases, also after the deduction of husband's share 1 by 2 or wife's share 1 by 4 respectively, the remaining balance which would be shared by the distant kindred. This is the principle. Suppose daughter's son and daughter's daughter are there. Then after the husband's share, that is 1 by 2, then daughter's son and daughter's daughter are entitled to succeed the property. Suppose wife is there, nobody, no any share and other residuaries. Then in such case, after the deduction of wife share 1 by 4, 3/4 will be returned to the distant kindred. Then only the distant kindred will come into the picture for the entitlement of the property after the deduction of wife or husband, if no other sharer are the residuaries which are left by the propositors. Suppose wife and maternal aunt, last one. Maternal uncle and maternal aunt. Maternal aunt is there and wife is there. Wife share is remain constant. As there is no child, wife share is 1/4 and 3/4 will be given to the distant kindred, that is maternal aunt. See how much the justification is done by the Muhammad Prophet in this regard. So that maternal aunt may be full blood or consanguine blood or uterine blood, but they are in the same under the 17th point. In the 17th point also they will be entitled to get it, provided that if no other legal heirs up to this 16th point which is available. This is the principle. Suppose if wife is not there and other sharers residuaries which are not there, then distant kindred is entitled to share the property. So up to that extent it won't come. Next one is that if no share, that is if no wife, husband, residuaries and distant kindred, then escheat will be operated. Escheat will be operated. Another point is that if only wife or husband which are left by the propositors, if no other heir, then wife will be given 1/4 or husband will be given 1/2 and the remaining balance of 3/4 or 1/2 respectively will also be returned to husband or wife. In such case, there is no question of application of the doctrine of escheat by the government. So this is the principle which is operated. Again, I am telling you about the important point of Rad. Here, husband or wife, their shares are remained constant. In case of the enhancement of the share, in case of Rad, that is enhancement of share, that is increasing the denominator so as to equivalent to that of the numerator, then the husband or wife share is remained constant. So there is no question of the enhancement of the property right towards the husband or wife. Next is, in the absence of the sharers and residuaries, if nobody else, if no sharer and no any residuary, only wife which is left by propositors and distant kindred are there, then after the deduction of wife, because wife share is remained constant, the remaining balance will be distributed among the distant kindred according to the order which is specified already. 1, 2, 3, 4 like that up to 18th and etc. So in such way, first one will be preferable to second, second will be preferable to third in the absence of first one. Like that, the property will be distributed in accordance with the order which is specified under the that is the distant kindred. Right. If no distant kindred, then husband or wife can be entitled to get entire property. So wife, that is as the process, 1/4 will be given, 3/4 is remained. So we can look after whether the others are there or not. If others are not there, then 3/4 will also be given to the wife. Suppose husband, nobody else, 1/2. 1/2 is kept. So in such cases, whether the other legal heirs are there or not, we have to look after. Nobody else. Then this remaining 1/2 will be returned to the husband. In such cases also, only the return will be operated if nobody else. If no any sharer or residuary or distant kindred, then only the wife or husband can get the return. Suppose if nobody else, either no wife, no husband, or no any other legal heirs. Hello? Hello? What is the disturbance? Huh? Hello? Madam?
Actually, one of the participants have unmuted. I have removed him for a time being.
Oh, okay. So if the disturbance will be there, because this tough law, madam, Muslim law is very, very tough. It is headache one. If anything disturbance will be there, mind will be diverted. That is the point. You have to safeguard me also. Right. So the government cannot take by escheat because husband or wife which are only left by the propositors, then return will be given to the husband or wife. In such particular point, whenever there is no any other sharer or any other the residuaries. Suppose if no husband, no wife, no residuaries, no distant kindred, then the estate will be operated. So the government will observe that particular property. That is the Rad. So points are there. That is some of the problems which are there. I am telling you. Suppose A dies leaving behind his mother and son's daughter, and son's daughter, both are sharers, and no residuaries. Then in what way their property will be divided? So here mother will be given 1/6 and daughter will be given 1/2. Then the denominator will come 6 and 1 plus 3. 1 plus 3/6 will come. Then 6 will be made as 4. Then 1/4 and 3/4. In such way, the share will be allotted because of the that is the denominator which is equivalent to that of share numerator, the adjustment which has been made. This is the principle. Thus, in the above illustration, this is explained. So I already explained to you. Next, problems. A Sunni Muslim leaving behind his heirs, that is widow, daughter, and his mother. Widow, daughter, mother. First of all, calculate whether it is more than 1 or lesser than 1. So 1/8, 1/2, and 1/6. In what way? You can tell me. 1/8, 1/2, and 1/6. Three plus 12 plus 4. 3 plus 12 plus 4 by 24. No. No. More. Three. 12. Okay. 4. 19. Okay. 19/24 altogether it comes. So 3 plus 12 plus 4/24. Then 19/24 altogether it comes. Then we have to make this 24 as 19. That is the rule applied according to the hint given by Muhammad Prophet. Then the problem will be solved like this. 3/24 plus 12/24, sorry, and 4/24 become in this way. That is 3/19. Next 1/19 plus 4/, 3/19, 12/19 plus 4/19. See, 3 plus 12 plus 4, 19/19 is equal to 1. In such way, the problem which would be solved accordingly. But the thing is that what happened here? Right. I think it is understood to you. So, I think it is understood, madam. The problem?
Yes.
Yes. So, actually, the problem will be like this. But the thing is that some exception is there. To say about that exception only, I am giving you this hint. So here, widow share is 1 by 8. So 1 by 8 is fixed and remain constant. Then the remaining balance is 7 by 8. The 7 by 8 which would be distributed to the remaining sharers, that is mother and the sister, daughter. So here daughter share is 1 by 2, mother share is 1 by 6. So 3:1 ratio. 3:1 ratio. So in such case 3 by 6 plus 1 by 6. 7 by 8 into 3 by 6, 7 by 8 into 1 by 6. See, calculate it. 1 by 8 plus 7 by 8 into 3 by 6. And 7 by 8 into 1 by 6. See, calculate it because you have to help me in this regard. So, one by 8 in the 21 by 48, then 7 by 48. So here 48 means R into 48. 21 See, madam, whether it is calculated or not, see, help that is, you can instruct the students to make it clear. So here, one by 8 remain constant, 7 by 8, and under that 7 by 8, daughter 1 by 2 and mother 1 by 6. 1 by 6. 3 plus 1. 7 by 8 into 3 by 6. 7 by 8 into 1 by 6. So here, 21 by 48 by 48. R into 48. 21 7 28 some trouble is there. Okay, madam. So in such way you can work out the problem. So mother share is 1 by 6, widow share is 1 by 8, and the daughter share is 1 by 2. After the reduction of 1 by 8, 7 by 8 which would be shared by the mother and also the daughter. So here you can bring that denominator. Denominator will be needed now. Six, 1 plus 4 by 6. Hmm. 1 by 4, 3 by 4. Right. 7 by 8 into 1 by 4. 7 by 32. And 7 by 8 into 1 by 4. 7 by 32. 3 by 4. 7 by 8. Okay, over, madam. Okay, 1 by 8. Means 4, 11, 28. Okay. Madam, you can see. My dear friends, the problem is solved now. So, wife share is 1 by 8, mother share is 1 by 6, and daughter share is 1 by 2. According to the formula of Rad, 1 by 8 must be deducted. Then 7 by 8 will come. Then the mother share and the daughter share you have to take into consideration. 1 by 6 and 1 by 2 is 2. 1 by 6 is 2, 1 by 2. Then 3:1 will come. 3:1 will come in case of the denominator. So 3:1 by 6 actually. 6 will be made as 4. Then 3 plus 1 by 4. That is 3 by 4 and 1 by 4. The remaining balance of 7 by 8 into 3 by 4 to the daughter, 7 by 8 into 1 by 4 to the mother, and 1 by 4 to the widow. Then the 32 by 32 will come. 32 by 32 will come. See, you can verify. Next one. Sunni woman dies leaving behind husband and mother. Then in what way the share will be? Husband is entitled to get 1 by 2 and the mother will get 1 by 3 plus the remaining balance of return will also be given to the mother 1 by 6. Totally it becomes 1 by 2 because the husband share is remained constant. This is the principle. A Sunni woman dies leaving behind husband and daughter. Then in what way? Husband share is 1 by 4 because the daughter is left by the Muslim. So the remaining balance 3 by 4. Actually, daughter will be given 1 by 2. Daughter will be given 1 by 2 and rest of 1 by 2 will also be given to the daughter. Totally, she is entitled to get 3 by 4. 1 by 4 and 3 by 4. Husband share is remained constant. In such way, the problems which are worked out. Any doubt in this regard? Next one, I will explain the another topic, that is disqualifications of the heirs. This is important one. Disqualifications of heirs. So, in what way the heirs which are disqualified under the law of inheritance of Muslim law? Under the Muslim law, just any other systems, persons are though heirs not to be entitled to share in the inheritance on account of their disqualifications. We have already studied in the Hindu Succession Act, murderer disqualified, the descendants of converts disqualified, etc. Like that Hindu law, some of the disqualifications which are arisen in case of the Muslims. So, what about the position of the non-Muslim, which is said here? Under the Islamic law, non-Muslim was not entitled to inherit the property from a Muslim. So, non-Muslim cannot be entitled to inherit the property from the Muslim. In India, it is not like that. A Muslim who had renounced the Islam, or ceased to be a Muslim, then he will be entitled to inheritance in the property of a deceased Muslim relation where he is. Suppose a Muslim has converted into the other religion. Suppose he converted into Hinduism. He is non-Muslim now because he is renounced the Islam. So here, in such cases, what is the position here? Just like under the Hindu law, convert is qualified, but descendants of convert is not qualified. Convert is qualified, but descendants of convert is not qualified. So the same principle which is operated here. Muslim has renounced the Islam or ceased to be the Muslim will be entitled to inherit the property of the deceased Muslim, whose heir he is. Whatever may be the others, but he is entitled to get or succeed the property, even though he is converted into the other religion. After the conversion into other religion, if any children will be begotten, then the heirs of that convert cannot be qualified for the inheritance of the property. So here, this is the principle. Next one is that, his non-Muslim descendants will not be entitled to inherit the property of the deceased. So non-Muslim descendants. So non-Muslim means who has converted into the other religion. Who has converted into the other religion. 1 minute, my wife has. 1 minute, please. Hello. Hello? 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 Right. So here, the non-Muslim is entitled to, that is, the person who is converted to other religion will be entitled to succeed the quantum of the property, but his descendants are disqualified from inheritance of the property. That is one principle. Next is murderer. So here, under the Hanafi law, whether the murderer is qualified or not. So here, heir who has caused the death of the deceased intentionally or by the accident or mistake or negligence or whatever, if in his hand or because of the act which is committed by the Hanafi, if the owner of the property, that is deceased owner of the property, that is that person is dead because of the acts of this particular man, either intentionally or accidentally or mistake or whatever, then in such case, the heir is disqualified and is excluded from the inheritance of the property. Next, under the Shear law, heir is disqualified only if the death is caused intentionally. So under the Muslim, that is Hindu law also, disqualifications of heirs which are there. So whenever the death is caused by one legal heir upon this deceased owner of the property intentionally, then intention will be taken into the consideration for the disqualification. Suppose if on the other way, if it is that is by mistake or whatever, by accident or whatever, because there is no any actus non facitrium nisi mensitria on the part of the accused person. That is why under the Shear law, she is allowed or he is allowed. But under the Hanafi law, under any circumstances, whatever may be the reason, she is or he is excluded from the purview of inheritance. Next is child in the womb of the mother. So here, child in the womb of the mother. Suppose the child is in the womb of the mother at the time of death of the propositus, and later the person is begotten and alive, or born and alive. That children will be entitled to inherit the property which is left by the propositus. So the stillborn children is treated as born and alive if its mother was treated with the violence as a consequence of which she gave birth to it. Because the mother, because of the pains and all these things, she that is the children which have been begotten. We are begotten because of the sufferings or labor pains of our mother. So that is why we have to safeguard the mother. First of all, you must know it, because it is another that is another birth is said to be given to the mother because of our birth. This is also important thing. So that is why we have to safeguard the mother. It is my moral suggestions to you. So here, the child in the womb of the mother, which would be considered as the child is born or alive, according to section 20 of Hindu Succession Act also, that treatment which is given under the that is Hindu law. That is why that principle which is already there under the Muslim law of inheritance. In Shear also the same principle. Next is illegitimate children. This is something difficult. Illegitimate children. Under unlawful law of inheritance, an illegitimate child is not entitled to inherit the property from its father. An illegitimate children is not entitled to inherit the property from its father, but it is allowed to inherit from its mother. So, from mother and mother's side legal heirs are that is from that side also the illegitimate children are entitled to inherit the property. This is the principle. Suppose example is there. Hanafi female dies leaving behind her husband and an illegitimate son of her sister. Hello? No noise, please. Behind her husband and an illegitimate son of her sister. So, under the Hanafi law, the illegitimate children will be entitled to get the property left by the propositors not only from its mother, but from the mother's relatives also it can get it. That is why here 1/2 will be given to the husband because there is no any children, and 1/2 will be succeeded by the illegitimate son of the sister of this propositors. This is the principle which is incorporated here. And under Itna Ashari, that is under the Shear law, it is the famous school, Itna Asharia. An illegitimate child is treated as nullius filius. So there is no any validity at all for the illegitimate child claim and cannot inherit the property of any of its parents. So from mother side or from father side or whatever, there is no question of inheritance of the property in case of Itna Asharia. Next is daughters. So here the daughters, in what way the consideration which has been given. So here the daughters as a rule are entitled to inherit the property because daughter is given the share 1/2, 2/3, and with the son she becomes residuary like that. But sometimes they are excluded from the purview of inheritance by customs or statute. So by way of custom or by way of statutes, the daughters are excluded from the purview of inheritance. In such cases, the shares of others are calculated by elimination of the daughter because the daughter will be presumed to be not to be in existence. That is the principle. So example, among Guzars of Punjab, in Punjab, some of the category are there. These are Guzars. So here one example I am telling you, if in Punjab, that is the 6 parents attended or parents visited the daughter's house and stayed for 10 days. So in such case, their custom and usage is that they have to pay the food and other, that is tiffin and all these things, charges to the daughter. Daughter should not say no, and they should not say that we don't want to pay the amount. In such way, there is no such. So it is the customs and usages of Punjabi people, Punjabi parents for the main, that is payment for maintenance of that 10 days whenever they are staying in the that is the daughter's home. That is their culture and that is their system and custom. So here, like that, in Guzars of Punjab, Guzars category persons of Punjab and Jammu and Kashmir, the daughters are excluded from the inheritance by custom. So that customs and usages says that these people, that is daughters of these people, cannot be entitled to get by the custom. Suppose daughter, mother and son are there. They are belong to Guzars. of Punjab or Jammu and Kashmir or whatever. Then in such cases, the daughter will be excluded from the purview of inheritance, and son and mother will share that property. So mother will be given 1/6 because of children, and son will be given the remaining balance, that is 5/6 as the residuary, and the daughter will be excluded by way of customs. That is the principle. They succeed to the property only in default of arguments. So if no any arguments which are left by the propositors, arguments means son's son, son's daughter, son's son's son, son's son's daughter, father's father, father's mother, father's father's father, etc. Brothers or brother's son, brother's son's son. They are all the arguments under the Hindu law of inheritance. So these arguments which are left by the propositors, then the daughter cannot be entitled. But if there are in default of that arguments, if nobody else, then the daughter can succeed the property in this regard. Next one, under Bombay Watan Act, another act is there. That is enactment. Under the previously, Guzars of Punjab and Jammu and Kashmir means it is the customs and usages. Bombay Watan Act means it is the enactment. A Muslim watender. Watender means who had the property in the Watan land under the Watan Act. Some place is there, in that some place that is called as the Watan land. That is called as the Watan land in Maharashtra. So here, for that Watan land, the Muslim, whenever he died by leaving the Watan land, he will be called as the Watander. Died leaving a widow, a daughter, and paternal uncle. These three are left by the propositors. So, according to law, the daughter cannot be entitled to succeed the quantum of the property. According to Watan Act 1886, daughter cannot be entitled. So, in such case, the daughter had no right to share in the Watan land, and the widow and uncle that take that land, succeed that land as if the daughter did not exist. So daughter is not there. By that presumption only, that property will be succeeded by widow and uncle. So widow will be given 1/8 because daughter is left by the propositors. Remaining 7/8 will be given to the uncle. In such way, share will be allotted. Next is insanity and chastity. These are not the disqualifications at all under the Muslim law. And in the Hindu law also, insane person is also entitled to succeed the property. Next is eldest son. Under the Itna Ashari law, one principle is oh, నేను చేస్తుంటే అత్తట్లేదు మరి నా నంబర్ నా జల్లి రైట్. సో ఏంటంటే తేడా ఏం తేడా ఉందా? ఓ నేను వెళ్తాను చెప్పు, ఏముంది అందులో తీసుకొస్తానులే, వచ్చామని చెప్తున్నా. రైట్. సో ది ప్రిన్సిపల్ ఈజ్ లైక్ దట్. నెక్స్ట్ చైల్డ్లెస్ విడో. Childless widow under the Itna Ashari law. Under Itna Ashari law, that is under the Shear law. Childless widow, that is 4 widows are there, 4 wives are there, and 2 wives have no children, 2 wives have children. Suppose, for example, that childless widow not entitled to share in the husband's land, both agricultural as well as urban. Suppose landed property which is left by the propositors, then under the Itna Ashari law, the childless widow cannot be entitled to inherit the land, whether that may be agricultural land or urban land. However, she is entitled to share in the value of the trees and buildings. So whatever the trees which are grown up from the land, and also the buildings, that is structures which are made on that land. For that only it can have a share, and also in the movable property of the husband. Movable property of the husband. Next, trees and buildings which are standing on the land, in that would be calculated, and that will only be given to the childless widow. But the childless widow, cannot be entitled to get a share in the land which is left by the propositors. Either it may be agricultural or it may be the urban land or whatever. But under the Hanafi law, all are entitled to succeed the property. So this is the childless widow. Eldest son. Now come to eldest son. So pray to that. Under the Itna Sharia law, the eldest son who is of sound mind is exclusively entitled to wearing apparel of the father, his copy of Quran, sword and ring, provided the father had left some other property besides this. So here, that is, in case of sultans, you know about it. They will wear the dresses, that is diamond rings which may be worn by him, and diamond buttons which may also be there for that dress or whatever. So up to that extent of that wearing apparel of the father. Wearing apparel of the father means hat may be having crores of the rupees, because diamonds which may be there, that may be arranged in the hat, and also the dresses, and also copy of Quran, and his sword, because he is sultan, his sword, his ring, his personal belongings are to be inherited by the eldest son, who is of sound mind, provided that if other property which is left by the propositors besides these things, if other property means the along with that, if other property means landed property or whatever which is left by the propositors, then the landed property which would be distributed to all according to the principles which are stated under the sharers, residuaries and distant kindred, along with this eldest son. That means eldest son is entitled to succeed the property of belongings of the father, that is wearing apparel of the father, that is dresses, hat, boots, and all this, the hand stick like that. They are all things which would be obtained by the eldest son. His copy of Quran and his sword and his ring, etc. He will be entitled. And along with that, if other property, that is landed property or whatever which is left by the proprietors, then the first son, that is eldest son, will also have the right to inherit this property. Right to inherit this property also, along with the personal apparel, that is wearing apparel of the father. Okay, childless widow I already explained to you. Next one is see, one case is there, Abdul Hamid Khan versus Pir Mirza. It was held that childless widow, in the absence of other heirs, was entitled to inherit not merely share, but also rest of the property, including the land of her husband, by the application of the doctrine of return. So, doctrine of return, when it would be applicable, that is important thing. So, the child, that is the widow, cannot be entitled to get the return according to the principle of doctrine of wrath. But the thing is that the childless, that is the childless widow, can also be entitled to succeed the quantum of the property if other legal heirs are not available. That is the principle. So stepchildren. So stepchildren cannot be entitled to, that is, they are not related to their step parents or whatever. So there is no question of connection in this regard. So these stepchildren are not entitled to inherit the property of their step parents or whatever. Next is హలో హలో తీసుకొస్తా మరి అయ్యింది ఇంకా తీసుకొస్తా సరే right. So the step parents, so they cannot inherit the property of the step parents because they in any of the way they are not related to step parents. Next absent here. So at the time of the distribution of assets, at the time of distribution of assets in case of inheritance, if heir is absent, even though he entitled to succeed the property. Suppose 2 sons and 1 daughter is there along with a widow. So widow will be given 1/8. Okay. Daughter and sons 2:2:1. That ratio will be given 2 sons and 1 daughter. 2/5, 2/5, and 1/5. So the rest of the health. ఓకేనా నీకు కొంచెం ఓకే చేసింది తీసుకో థ్యాంక్ యూ రైట్ సో 7/8 share after the deduction of wife share, the 7/8 will be distributed among all of the others. So here the 2 sons 2:2:1, 2/5, 2/5, 2/5. Among them 1 son is absent at the time of the distribution of the property. Then the property will be kept to him until he is presumed to be dead. So if that person is dead, if any information comes, then up to that extent of getting the information, the property which would be kept separately for him only, because there is no any proof at all that he is dead. So till death of the person, till he did not come and there is the information that he is dead, then in such circumstances the property will be kept apart. That is till he comes. If any that is information which is obtained, then automatically the person that is said to be dead, then that property will be succeeded by the parties that is relating to that property. This is the principle which is incorporated here. Now, is there any doubt you can ask me? I shall explain.
Okay, sir. We have some queries in the chat box, sir.
Yes, queries you can ask me. I shall explain.
One from Anwar Hussain. He wants to know what is the right of Muslim divorced women in maintenance? What is the right of rights of Muslim divorced women in maintenance?
Maintenance. So maintenance is under the family law 1 year. It is not the succession, isn't it?
Yes, but
is it correct or not? Is it correct or not?
Yeah.
Yes,
But then
yes.
I did not deal with that family law 1. So my answer it may be wrong. Okay? In succession only you can ask. In succession you can ask.
Okay, sir. Next question is from Sansuli Bahama. She wants to know, is widow become an inheritance in Muslim law?
The widow becomes?
An inheritance in Muslim law. Inherit property.
Widow will also be entitled to succeed the property under the Muslim law. Under the that is Shearer's list that is there, widow. Under the Itna Ashariya, this is disqualified. Under the Itna Ashariya, childless widow only is disqualified from the inheritance of the property of the landed property left by the husband, either agricultural or the non-agricultural land. Okay? Right? That is disqualified. But in case of this Hanafi law, there is no such disqualification. Next.
I think there is no more questions in the chat box, sir. Dear participants, if you have any queries, then you can directly interact with sir. Anyone wants to interact with sir?
Yes. What, madam? Understood the subject?
Yes,
Madam,
yes, sir.
you understood the subject? Your students understood? Huh?
Yes, yes, sir. Yes.
Ah, because time limit is specified by you. Because the student cannot bear it. Huh? From 10 we started it, but till now the students are there. They are listening it. Because in the next time, how can we? This is also a problem. Again, next week only. In the meantime, they will forget this material, today's lecture. Huh? Isn't it?
Yes.
That is why I finished it by went on speed. Okay?
Uh,
Huh?
yes, sir. Yes, yes.
Thank you. Next.
Thank you, sir. Thank
Doubt. You can encourage the students for posing the doubts, especially under this chapter.
you. Okay, okay. So,
Ah,
dear students and participants, would you like to interact
ah.
with school?
Students, they can ask. I shall explain, madam.
There is another question.
Ah,
Can a Muslim inherit from a
wait,
non-Muslim?
wait, 1 minute, 1 minute. Not clearing. Tell me, madam.
Yeah. So I think this has been already explained by you. Can a Muslim inherit from a non-Muslim?
Yes. Can a Muslim can inherit from non-Muslim means who is non-Muslim? You can tell me. First of all, that must be none. So the Muslim who can convert into other religion or who renounced the Islam. Okay, madam.
Yes, yes, yes.
So here he can be entitled to inherit the property from the parents. The convert is entitled to inherit the property from parent. Okay, but his legal heirs, that converts legal heirs are converts converts legal heirs are not entitled. Okay. Next another one I will clarify. Suppose he has converted into the Hinduism. Then after the death of the person who has converted into Hinduism, then Hindu law will be applicable, and according to sections 1 to 30 of Hindu Succession Act, the provisions which would be followed. That is class 1 heirs, class 2 heirs, agnates, cognates, these all things are there, they are entitled to succeed the property. Class 1 heirs, you know about it: son, daughter, widow, mother, son of priest, son, daughter of priest, son, widow of priest, son of priest, daughter, daughter of priest, daughter, son of priest, son, daughter of priest, son, and widow of priest, son of priest, son. And 4 are added according to the Hindu Succession Act 2005. That is 4 are added from the class 2. It is not necessary because you are expert in that particular field. So they are entitled to succeed. Right. Right, madam? Clarified?
Yes, yes.
Next one, come. Is there anybody else for posing the doubt?
Duhita, I think there are no more, so you can proceed.
Okay. Thank you, sir, for enlightening us with your elaborative explanations on pertaining to the topic, and also sharing your valuable thoughts and experience. So I hope it will be highly beneficial for all of us.
Thank you.
So now I would like to request Suresh Basumatari, coordinator of IQAC cell, to deliver the vote of thanks for the session.
Okay. Thank you, madam.
Okay. Thank you all. On behalf of Professor Law College, I see Suresh Basumatari, IQAC coordinator, Professor Law College, would like to offer vote of thanks of today's 60th episode online lecture series. At first, I would like to thank today's keynote speaker, Professor Dr. Nagabhushanam Tida, for such a guiding and valuable lecture on the topic Muslim law of inheritance. I hope these sessions would be benefited for all the participants. Thanking you so much, sir, for your energetic, valuable lecture with your long experience of teaching and gracious presence on today's webinar sessions.
Thank you.
Thank you, sir. Thank you, sir.
Thank you. Thank you very much, madam. Thanks
Yes,
very
sir.
much.
I would like to thank our principal, I see, Ms. Prita Brahmo, ma'am, for organizing this valuable webinar sessions. I also would like to thank all the esteemed colleagues joining us. Lastly, I would like to thank all the students and other dignitaries who are joining us from different fields and other institutions on today's webinar. Once again, thanking you all for truly memorable morning, and hope you can join us in future. Have a nice day ahead. Thank you all.
Thank you. Thank you. Madam, madam, 1 minute. 1 minute, madam. Hello, Lavanya. Lavanya? You show you show your face. See, madam, Lavanya, you say it, Lavanya. Madam.
Yes, I can see her.
Wait. No. I am introducing you to madam. Madam Lavanya, High Court advocate. With interest, she joined in this group to know about the subject of the Muslim law. She was my student. She was my student of 5 years BL course, and she finished it, and now she is practicing in the High Court of AP.
Nice to have
thank you.
Us, madam.
Thank you.
Lavanya,
Thank
madam,
you.
thank you.
Nagabhushanam garu.
Hello.
Very good lecture. I am from Rajamundry, Ravanamurthy. I am Ravanamurthy
Oh,
from Rajamundry.
so in that is in car I saw it, isn't it? Car?
Yeah.
Ah,
I am
right.
continuing following your lecture.
Thank you very much, Mr. Ravanamurthy. Ravanamurthy, thank you. Thank you.
Valuable lecture you are given
Thank you.
about Muslim law.
Yes.
Thank you, sir. Thank you very much.
Thank you very much. Okay, madam. Thank you very much for giving me opportunity.
Thank you. Thank you, sir.
Uncle, one
Thank you
second.
for joining us.
Thank you.
1 second, uncle.
Hello.
Hello. 1 second, uncle.
Tell me.
Yes, this is Narasimha from your friend's son.